It is the appointed time. I call to order the meeting of the Subcommittee on Safeguarding National Security, Procedural Matters Regulation. Item 1, meeting with the administration. I will ask the Secretariat to invite the government officials to come in. Members, first of all, my heartfelt thanks to you all that in such short notice you attend today's meeting. Now, the geopolitical tension is fraught and Hong Kong's national security risks are real. Earlier on, the chairman of the House Committee has convened a special meeting to deal with the subsidiary legislation. At the meeting, a decision was passed to establish a subcommittee with me chairing the subcommittee to scrutinize this piece of subsidiary legislation. Subsequently, the Secretary for Security has sent a letter to me stating the urgency of the legislative work. And under the principle of as early as possible, he asked me to convene a meeting of the subcommittee as soon as possible. I fully agree with that suggestion. That's why I decided to convene today's meeting to take forward the scrutiny work. Here I welcome Mr. Paul Lam, Secretary for Justice, Ms. Daphne Siu, Law Officer of the DOJ, as well as the DOJ team, as well as Mr. Chris Tang, Secretary for Security, as well as his team. First of all, I will invite the DOJ to walk us through the paper. Now, the subsidiary legislation, that is Legal Notice 67 of 2026. For the background, please refer to the following papers set out on the agenda. 1. The Legislative Council brief issued by the DOJ and the Security Bureau on the 9th of June, and also the LSD report, that's LS 27, 2026. Now, we will now discuss the policy matter of the subsidiary legislation. To manage time, please press the button if you wish to speak, and I will defer to the Secretary for Justice. Mr. Paul Lam will walk us through the legal principles of the subsidiary legislation, and then the Secretary for Security will walk us through the contents. Chair, members, first of all, on behalf of the Hong Kong SAR government, we thank the chairman of the House Committee, the president of the Council, as well as the Electrical Secretariat for making arrangements to convene the House Committee special meeting this morning to establish this committee to pass the Safeguarding National Security Procedural Matters Regulation, which has been gazetted on the 9th of June. I thank members for joining the subcommittee and for Ms. Carmen Kan for chairing the subcommittee. Now, as I've mentioned earlier on, the Procedural Matters Regulation is established under the existing mechanism under the Hong Kong NSL and the Safeguarding National Security Ordinance. The objective is clear. That is to state clearly the classification mechanism under the Hong Kong NSL and SNSO for other offences endangering national security under the law of the Hong Kong SAR, so as to give greater certainty for the carrying out of the provisions. There are only 3 provisions. They are very clear and simple. They are in accordance with the scope of the Section 110 of SNSO. The applicability scope of the SNSO has not been expanded, nor is there any new criminal offences, penalties, or enforcement power. However, some members of the public have raised concerns on the Procedural Matters Regulation. Some media and overseas elements with ulterior motives have made false accusations against the Procedural Matter Regulation. Now, taking today's opportunity, I would like to highlight 2 points to clarify the air. To clear the air. First of all, concerning the CE's certification mechanism. All major common law jurisdictions have case laws stating that the executive branch respects the judiciary, respect the decision made by the executive branch on national security matters. Now, there are three cases I would like to quote. The first one is in 2003, a Privy Council's case law, which states that under the Constitution of the UK and other common law jurisdiction, whether a matter is in relation to national security is not a matter for the judiciary to decide, but rather the executive branch. The second case is a case in 2010. It's a U.S. Supreme Court case law explaining why the judiciary must respect the executive branch assessments on national security matters. The court points out that national security and foreign affairs matters are closely related to dealing with evolving risks. Information in this realm is very hard to come by, and it is very difficult to assess the impacts. The court lacks the capacity to make judgments on the relevant matters. Now, back to Hong Kong in 2004 concerning an injunction order application, the appeal court ruled that based on the different duties of the executive branch and the judiciary, where the executive branch is responsible for assessing and dealing with national security, while the judiciary is responsible for independent legal proceedings. Only the executive branch possesses the experience, resources, and intelligence suitable for dealing with these matters. They are the ones to deal with national security matters and make assessments. Now, these assessments are legally binding in accordance to Article 47 of the Hong Kong NSL under the certificate issued by the Chief Executive. On ordinary circumstances, courts would respect the assessments made by the executive branch. Now, these cases show that in the UK, the US, and in Hong Kong and other common law jurisdictions, matters in relation to national security have never been the jurisdiction of the judiciary, and the executive branch is more capable to make a judgment and assessments on national security matters. Now, according to Article 43 of the Basic Law, the Chief Executive is the chief official of the Hong Kong SAR. He needs to take responsibility on national security. He is also the chairman of the Committee on Safeguarding National Security. The Chief Executive is the principal responsibility holder of national security in Hong Kong. He has access to sensitive and confidential intelligence. He is in the best position to assess whether an act endangers national security. It shows that under Hong Kong NSL and the SNSO, this certification mechanism is fully in line with the common law principles, and the Chief Executive and the judiciary are playing their respective roles. Now, the judiciary would hear the cases independently, consider the evidence, and rule whether the defendant is guilty and ensure that there is a fair trial. Now, the second legal point is in relation to the subsidiary legislation, whether it is retrospective. I can clearly say that the procedural matters regulation does not have retrospective power. It does not apply to cases which have already completed the proceedings. Now, according to Bill of Rights, Article 12, legislation for enhancing penalties as well as establishing new offences do not apply to acts done before the legislation. Now, the offences and penalties set out in the Hong Kong NSL and the SNSO do not apply to acts performed before the laws were enacted. Now, concerning other offences endangering national security under the law of Hong Kong, now, from the background of the legislation of the Hong Kong NSL, when the central government enacted this law, the central government has considered that there are other offences endangering national security under the law of the Hong Kong SAR. Now, Mr. Wang Shen of the central government, when publishing the draft decision of the National People's Congress on establishing and improving the legal system and enforcement mechanisms for the Hong Kong SAR to safeguard national security mentioned that there were some existing laws of the Hong Kong SAR enacted before Hong Kong's return to the motherland, which could have been used to safeguard national security. Now, concerning the prosecution of those cases, Section 1(2) of the Procedural Matters Regulation sets out that once the certificate is issued, whether the prosecution or the conviction are made before, during, or after the Hong Kong NSL, they would be criminal acts and offences under the national security law. This provision is fully in line with the Hong Kong SNSO, as well as the Bills of Rights and the Basic Law. Now I will defer to the Secretary for Security to explain the contents of the Procedural Matters Regulation. Afterwards, we will be pleased to answer members' questions concerning the policy, legal matters, as well as the drafting of the regulation. Mr. Chris Tang. Thank you, Chair. Once again, I thank all members who are attending today's meeting. Thank you for establishing this subcommittee swiftly and convening a meeting so that we can complete the negative rating as soon as possible. Now, before I move on to the specific contents, I would like to emphasize 2 points. First of all, certification issued by the Chief Executive under Article 43 of the implementation rules, as well as Section 7 of the SNSO, to decide whether an act is an act endangering national security. The mechanism has always been there. The regulation has not changed the provisions, but rather give more certainty on carrying out the provisions. The Procedural Matters Regulation will not change the provisions in relation to cases involving national security, and there is no new offences, penalty, or enforcement power under the regulation. Second, I am aware that there are some misunderstanding or even deliberate distortion towards the regulation. Now, just now, the Secretary of Justice explained the mechanism of certification. I will not repeat the point, but I would like to clarify several points or even rebut some accusations. Now, some have tried to scare the members of the public that the regulation would expand the scope of the national security law and would render some normal offences as offences endangering national security. This is outright lie. First of all, the regulation does not change the rule concerning other offences endangering national security under the law of the Hong Kong SAR. It would only give more certainty to the carrying out of the provisions. There is no new offences, enforcement power, or penalty. Now, if an offence is assessed to be an offence endangering national security, according to the regulation, there's only one reason. That is because the act is in the nature of endangering national security. That's why the offence would be an offence endangering national security. The Procedural Matters Regulation will not render minor offences national security offences. In fact, under the Hong Kong NSL, the SNSO, and the implementation rules, the definition of national security offences have covered most of the criminal acts endangering national security. Now, according to the regulation, the Chief Executive can issue a certificate to classify other acts as endangering national security, but that would only be the minority cases. Now, most national security offences are clandestine and of a very diverse scope. The Procedural Matters Regulation's objective is for dealing with these other few offences which will endanger national security. And also, there are some people who try to stoke fear by saying that after the regulation is enacted, the Hong Kong SAR government can render any act committed by the members of the public national security offences. Now, these accusations, intent, are vicious. They try to stoke inharmony in society and distrust in the government. An act which is not a criminal act will not become an act of endangering national security just because the CE has issued a certificate. That's impossible. We have to stay alert against these false accusations and also their malicious intents. In the following, I will explain the contents of the regulation. First of all, there are only 3 provisions in the regulation. The first one is for classifying what offenses are national security offenses. The second one is about alternative offenses will also be national security offenses. The third one is about the provisions relating to security offenses in law under Hong Kong SL and SNSO. Now, in Section 1, Brackets 1 and 2, it says that if the Chief Executive, in accordance with Article 47 of the Hong Kong SL or Section 115 of the SNSO to certify that an act concerning the case involves national security, and the case is a case concerning offence endangering national security mentioned in Article 41 of the Hong Kong NSL, regardless of whether the act was done or the prosecution was brought before, at the time, or after the Hong Kong NSL came into operation. For the purposes of the case and any proceedings in connection with the case, the offence being investigated, arrested, or charged in respect of such acts is an offence endangering national security under Section 7D of the SNSO. 1(3) says out that according to Article 47 of the Hong Kong SL and its relevant interpretation, that is the draft decision of the National People's Congress on establishing and improving the legal system and enforcement mechanisms for the Hong Kong SAR to safeguard national security. Number 14 and 47, the Chief Executive certificate shall be binding on the courts. Therefore, the Procedural Matters Regulation provides that the certificate is not liable to be questioned in any court, and no legal action of any form may be instituted in respect of the certificate. Section 2. If a person is charged with any offence endangering national security and is charged with or convicted of any alternative offence in respect of the same act in the same case, such alternative offence is also an offence endangering national security. Section 3. Reiterating the provisions relating to national security offences in laws such as the Hong Kong NSL and the SNSO. As I've mentioned, if a case is a case concerning offence endangering national security, or an offence is an offence endangering national security, the provisions relating to national security offences in laws such as the Hong Kong NSL and the SNSO shall all apply to such case and offence. To avoid doubt, the Procedural Matters Regulation, Section 3, reiterates that provisions that are applicable to an offence endangering national security in the law of the Hong Kong SAR, such as Chapter 4 of the Hong Kong NSL and the SNSO, shall apply to cases concerning offences endangering national security, including offences endangering national security that are classified under the above mechanism, as well as proceedings in connection with such case. Chair, the Procedural Matters Regulation can clarify the mechanism. It can enhance the legal system and the enforcement mechanism of the national security law in Hong Kong. I invite members to give us your views. The SJ and my team will be happy to take your questions. Considering the complicated geopolitical landscape, there is still lurking national security risks. We need to enhance the mechanism for safeguarding national security as soon as possible. Thank you.
I'd like to thank the two secretaries for making the clarifications that some people with ill intentions have been trying to smear the procedural regulation. We have slotted up to 4 p.m. for this meeting, so let's have questions on the procedural matters regulation before we proceed to the cross-examination. The first one to ask question is Ms. Kenny Ford, followed by Ms. Jimmy Ng, Ms. Maggie Chan, Mr. Yang Wing-Kit, Ms. Nick Chan, Reverend Peter Douglas Kuhn, Mr. Chan Hak-kan, Mr. Chan Xiu-hong, Ms. Judy Chan, Mr. Stanning, Mr. Holden Charles, Ms. Shu Ka-Fight, Dr. Priscilla Leung, and Mr. Thomas So. And I will follow after that. Ms. Canifor, I thank the Secretary for Justice and the Secretary for Security for making the clarifications and quoting some examples to elucidate the intention, the legislative intent of the procedural matters regulation, which is to safeguard national security. Together with my constituent and the group and the members in my group, 17 of them, we all support the enactment of this regulation so that we can progressively take up measures to better safeguard national security. As you can see on the internet, there are people with ulterior motives to try to shift the focus to the CE certificate mechanism. But that's not really the real focus. We are just trying to focus on how to define with greater certainty what offenses there are which are endangerous national security in nature. My question is that during the trial of a case and then the CE issue a certificate, and then the case in question would adopt these procedures applicable to a national security law case. Would there be an instance switch to national security judges, or is that just a choice open to the court? What if a jury is already in progress? Would there be the immediate scrapping of the jury and then revert to the original procedures applicable to national security cases? Of course, I agree that we should take action as soon as possible to adopt measures to better safeguard national security. So that's my position. Thank you. All right, we should follow the due process. Secretary, as Mr. Fogg has said, in the course of the trial, the CE issues a certificate certifying that this is a case concerning offense endangering national security. Under the procedural rules, the case should be tried by a national security judge. And if that's already a jury in progress, then even though we will follow the right procedure, the Secretary for Justice will issue a certificate to indicate that a jury should be dispensed with. That depends on the case in question. And if the Secretary for Justice does not issue a certificate to that effect, then the jury will continue to work as to whether the case should just continue or not. That would be up to the judge. The important thing is to ensure fairness and justice so that we can have fair trial. Secretary for Justice, thank you for your question, Mr. Fogg. I think the possibility of having such a scenario as mentioned is very low. Well, of course, certainly we would make a very careful assessment before proceeding with prosecution. So it would be very rare that such a scenario would come to pass. And even if it's a case concerning national security, it doesn't mean that there will be no jury. It's the power of the Secretary for Justice to ask that the trial proceed without a jury if if in his will we need to protect the juries and their family members. Mr. Jimmy, understand under Section 47 or Section 110 of the Hong Kong NSL, he can issue a certificate to specify, to stipulate that a case is a case concerning subsidiary endangering national security. So how can we have a piece of legislation that can help us clarify the matters? Of course, if a case has been tried, and then because of the lack of sufficient evidence, then there may be an alternative charge. And according to the new regulations, the alternative offense is also deemed to be an offense concerning national security. But if the accused is facing a number of offenses, if one of them is an offense concerning national security, then will Section 2 of the new regulation be adopted and deem those other offenses as offenses concerning national security? Or during the trial, the evidence shows that there is a need to press more charges. Will those additional offenses so charged be deemed to be offenses concerning national security? The question is, what are the principles to decide whether certain other offenses should be charged as alternative charges? Well, I'm saying that let's say the accused is facing 3 charges. The first 2 are offenses concerning national security, but the third one is not. Should all the 3 charges be proceeded with under the national security procedures? We're 7D, and we talk about the implementation details, the Hong Kong NSL, and then under the Section 7 of the SNSO, under D, other offences endangering national security under the law of this Hong Kong SAR, and then we have the CEs who is empowered to issue a certificate, a particular offence to be such an offence under D. So we want to avoid arguments about whether an offence before a charge before the court is such an offence under that particular limb. So under the new regulation, if the CE issues a certificate, it is, and if it's no certificate issue, it's not. For example, if the offence is a possession of explosive, and the act is possession of explosive of explosive. You may charge the person with offenses under the terrorism laws, and the alternative charge will be possession of explosives. So we have to talk about this particular act. And then if there's another charge of possession of drugs, then the CE certificate will not turn that particular possession of drug offense into an offense concerning national security. The member talks about the alternative charge being minor in comparison. That may not be the case. It's just that the different ingredients of the offense will be required to be proved. And also additional charges is something that we can only take up with the approval of the court. And the additional charge has to be dealt with independently. So it will not be subsumed under this particular procedure. Ms. Becky Chen, whether the CE has the power to issue such a certificate and whether this can be questioned in a court, well, it's actually already mentioned in the sections concerned, Section 115 of the SNSO, and also under 7D of the SNSO and CFA judgments have affirmed the relevant rules. This time, the procedural matters regulation would provide the necessary details and certainty for defining or specifying of whether an offense is an offense concerning national security. Before we have the new procedural matters regulation, for example, we have people charged with succession coupled with fraud or publication of subversive information. Then will the new procedural matters regulation affect cases such as this, which involve multiple charges, or would the procedure remains the same? Well, actually, we are talking about how how the offenses are defined. 7D, Section 7D doesn't specify what offenses are covered. And now we are saying that these are the offenses for which the CE has issued a certificate. For those without the CE issuing such an offense, they are not. Oh, in a case involving multiple offenses, multiple charges. That's a question. Yes, my question is about the case whereby the accused is facing multiple charges. One of them is an offense concerning national security. The other may be about subversive speeches and acts. Or if there are more than an offense, we will have to look at whether those are alternative offenses or they are different in nature. For example, if someone is arrested for the terrorism offense and he's in possession of explosive, and it's suspected that he was trying to blow up a government building, and he is also in possession of fake money. But this offense is not related to national security. So the new procedural matters regulation will not turn these offenses into offenses concerning national security. But if the accused is facing a terrorism offense prosecution, but there's an alternative charge which we think might be also appropriate, which is possession of explosive. And then if the court thinks that it's appropriate to convict the accused of the alternative charge, that is to say, the alternative offense of possession of explosive, and then the question is, will the C certificate transform this offense to an offense concerning subsidiary legislation? So the question can be answered by looking at whether the alternative offense or the main offense is an offense concerning subsidiary legislation. Well, I was talking about subversive speeches or incitement, inciting, involving the use of speech. Then would one of the charge has been issued, has been covered by a C certificate. Well, that would be covered under 7C, the offenses under the SNSO. Of course, our focus is 7D, but 7ABC would cover the majority of related cases. Well, 7D is really a catch-all provision. Actually, 7A, 7B, and 7C are already very clearly defined and specified. Mr. Yang Wing Kit, I support the subsidiary legislation. It doesn't involve the creation of new offenses or enforcement power, but the subsidiary legislation can bring about more certainty in the enforcement of law safeguarding national security. My question is that the C can issue a certificate either for X before or at the time or after the enactment of SNSO, and the certificate can be issued either before or during the trial of case. So I would like to know the mechanism. Who would decide on the timing of issuing such a CE? It's been suggested that you can be subject to a new procedure just for the offense of sneezing, even when the CE issues such a certificate. I think that's of course an exaggeration, but the media may not, and the general public may not be very familiar with the full contents. Are you going to issue some easy to understand briefing material for the consumption of these people? Well, as the C has said, as we have also mentioned earlier, the issue of C certificate is a very solemn and serious procedure. It's a matter of a fact, as we have mentioned that in some foreign jurisdictions, it's because the executive authorities have the information and the evidence to judge, to assess whether an act or is related to national security, is an offense concerning national security. That's also the common law system and ways of handling such matters. Well, of course, when the certificate is issued, the court will know, the accused will also know, and of course, the trial is open, and the relevant parties and the general public will know that the CE has issued a certificate. What about briefing matters, briefing material? Well, we can, of course, issue some easy to understand at a glance briefing material for the general public to better understand the content.
Next one is Nick Chen. Well, in our country, there's no family, so therefore I support the latest amendment. And the legal system to ensure national security. In many common law jurisdictions like the UK, USA, Australia, Singapore, they actually leave it to the executive authority to decide whether national security is a risk. So there's nothing wrong with what Hong Kong is now doing. The enactment of the making of the subsidiary legislation is legal. And I've got a question here. You, at the joint panel meeting, said that in the case endangering national security, alternative charges could be seen as endangering national security. I'd like the administration to, however, clarify further what is the maximum penalty of alternative charges, and will the maximum penalty unaffected? And also, what about the burden of proof required? Okay, let me answer. The penalty for alternative charges will not be affected. In all the clauses, there's no mention of any impact on the penalty. And the concept is that for an existing charge, if there are alternative charges, then we need to lay the charges based on the same facts, same evidence. It's just that we are leaving it to the judge to decide whether they want to accept the original charge or what. So whether it is the original charge or alternative charges, the sentencing or the maximum sentencing would not be affected. And the court will also uphold the same criteria for admission or acceptance of evidence. So the answers are very clear here. Next one is Peter Douglas Kuhn. Thank you, Chairman. I do support this subsidiary legislation, but Chairman, I noticed that even though the Secretary explained for trivial matters, we know the implications, but there could be embarrassing cases, like someone says that I'm dressed in black at a particular location on a sensitive day. So would that endanger national security? So the public, even, well, for people crossing the streets, of course, there'll be no issue with national security, but I'd like the administration to explain more about certain acts. And also on alternative charges, as the Secretary said, that the sentencing for alternative charges may not be lighter. But in fact, in some cases, people would plead guilty to alternative charges to receive probably a lighter sentence. So when it comes to national security crimes, with this new subsidiary legislation, people would choose to plead guilty to a lighter offense instead, in light of alternative charges. Two questions. On your first question, Reverend Kuhn talked about possible scenario. Well, we can't just make a sweeping conclusion here, but it all depends on the evidence. Say you're saying that if there are some acts which are related to national security, then we could, by invoking NSL or SNSO, to make an arrest and lay a charge. That is, if an act itself is seen as violating the national security law, then there will be no need for the chief executive to issue any certificate. So I and the Secretary for Justice kept mentioning that the scenarios you mentioned are very rare, because most of the cases related to national security indeed are already covered by the NSL and the related laws. Cases which require the chief executive to issue a certificate, those cases are not common at all. And I think the scenario you mentioned, well, it depends on what really is happening at the location, what evidence we have that can help us decide whether we should lay a charge based on NSL. And then on alternative charge, well, the charge could be different from the NSL charge in terms of the elements, but it's all based on the fact. And if the fact shows that the act is related to national security, then a certificate may be issued by the chief executive. An alternative charge, should a sentencing would not exceed the charge of NSL, then it depends on what the charge is. So whether a particular criminal offense, whether an NSL charge becomes an alternative charge resulting in the same sentencing, I think there's no need for worry. It all depends on what the nature of the original crime is. So since the sentencing would not be changed, it will all be based on the possible maximum penalty of the alternative charge, not because it's an alternative charge coming out of an NSL charge. The same burden of proof and also the criteria for proving your innocence is the same. So therefore, the same standard of sentencing apply. What is different is that there would be changes in the proceedings. That, for example, the length of detention could be longer in the alternative charge in the context of national security law violations. Next one, Chen He-Ken. In the past few days, people were talking about procedural matters regulation, and there's much focus on the chief executive issuing a certificate. As explained by the secretary, there could be misunderstandings involved or active smearing, or there could be comments made deliberately to suggest that the regulation is outrageous or above the law. Some even claim that it is a doubling down on NSL. But just now the secretary said that this is our latest regulation actually can be found in other common law countries or jurisdictions. So I'd like the secretary to explain further. In other common law jurisdictions, the certificate issued by the executive authorities, what kind of mechanism is involved? And why is it that in those jurisdictions it's the executive authorities which issue the certificate and not the court? What are the difficulties behind? Can you give us a simple explanation? And also, there's also the saying that issuing the certificates by the executive authorities would undermine the independence of the judiciary. Secretaries, I'm sure you don't agree with that, but can you use layman's terms, explain to us what you think on that, and can you offer us the clarifications? Secretary, for your first question, we, together with our colleagues, carry out research in other common law jurisdictions, and we came up with some examples, like a case in Ireland. Later on, my colleague can give you the details. And also, well, there are lots of examples that you can find indeed. I've noticed that many members in the legal profession, in order to dismiss unnecessary worries, they've also come up with examples, like Ronnie Torn also cited good examples for us, and he cited British cases and so forth. So later on, I will get my colleague to supplement. On question second, why is it that the same approach is done in other jurisdictions? There's no coincidence. Why is it that when you have to make a judgment whether an act infringes national security, that's what we need to do. But why is it that, as you can see, in all common law jurisdictions, all accept that the judgment should be left to the executive authorities, not the judiciary? It's not a coincidence, because what factors do you need to you need to consider a basket of factors in making the judgment. There's a judgment call there. So for you to make an appropriate judgment in defense of national security, you need to consider a host of information, including confidential, sensitive information. So the question is it what lawyers, judges trained to do? The answer is definitely not. The most reasonable is for the executive authorities to shoulder the responsibility to carry out the intelligence, analyze intelligence, and so forth. So that must be the work of the executive authorities. So the same rationale is upheld in other common law jurisdictions. So I'll ask my colleague to give you more examples, give you concrete examples on the actual mechanism. Mr. Ivan Leung, please. Thank you, Mr. Chen, for your question. Since we've done our study and we found that in various jurisdictions, depending on their own domestic situations, on cases involving criminal or civil cases involving national security, they have special procedures, including issuing certificates by the executive authorities to decide whether the case could be an infringement of national security. And this ties in with what the Secretary said in his beginning speech. That is, the judiciary needs to respect the executive authorities in making the judgment. In the UK, you may find that in 1997, there's a special Immigration Appeals Commission Act, and is 2002 Nationality, Immigration and Asylum Act, in which there is the stipulations that if the Home Secretary issues a certificate showing that judgments on immigrant cases based on security justifications or diplomatic or public interest reasons, then the cases should not be open. Then the persons affected would not be allowed to go through normal procedures to appeal against the decision by the immigration authorities. Any act of appeal must be submitted to a special committee following designated legal procedures, including that some of the hearings may not be open to the public and some of the information may not be required to be shown to the persons making the appeal. And in Ireland, there is a civil case in Offences Against the State Act, which involves dealing with national security, terrorism, and organized crime legislations. It's written that if the government accepts that for certain types of acts and that the courts cannot uphold national security and judicial fairness, then such cases could be declared as scheduled offences. And any charges under these offences or in relation to these offences must be dealt with by a special court. And even for those acts, individual cases not covered by the scheduled acts, if the Irish authorities, that is the Attorney General, decides that on the trial of that particular cases, the usual courts cannot ensure effective public security and judicial fairness, then the Attorney General can issue a certificate requiring that the case involved be heard by a special criminal court. So you can see that in relation to the national security law in Hong Kong, the procedure and design are the same. They are consistent with our design here. So now any conflict between the chief executive issuing certificates and independent judiciary, there's no conflict at all. What we mean by independent judiciary means that there should be no person affecting the judgment of a judge. So the chief executive role is only to decide whether a case is related or involves national security. The certificate cannot possibly be made or be seen as having an effect on the sentencing or the final judgment of a court. So they are two separate issues indeed. Next one is Chen Siu-hong. Thank you, Chairman. The NSL and the NSO have been functioning well, but we cannot be complacent. National security is a continuous work, and the relevant regulations, laws, and enforcement mechanisms need to be continuously reviewed and enhanced. If there's any need for clarifications or change, then we need to act. Therefore, I support the government's move to, in accordance with Article 110 of the NSL, to clarify and stipulate clearly under local laws the mechanism for determining offenses related to national security. And also, the chief executive should, before or during the legal process of a case is on, the chief executive can issue a certificate. And recently, you mentioned that online there have been a number of comments made by people with ulterior motives who seem to be making sense, but indeed they are quoting or citing facts out of context. They claim that based on Article 41 of the Hong Kong National Security Law, saying that Hong Kong Special Administrative Region, the Court of Hong Kong shall obtain a certificate from the Chief Executive to certify whether an act involves national security or whether the relevant evidence involves state secrets when such questions arise in the adjudication of a case. So that shows that they claim that only the courts can obtain certificate by the Chief Executive and also during a judicial process or trial. And they claim that the Chief Executive has no power to issue a certificate on its own. But I think the claim is or unsubstantiated. It says that the Chief Executive, when he thinks appropriate, can issue the certificate. But quoting Article 47 of the Hong Kong National Security Law, but all these claims are taken out of context. So can the administration explain clearly under Article 47 of the NSL and also Article 110 of the NSO? Can you give us more clarifications? Yeah, National Security Law Article 47 states that when the court is handling a case, which raises the question of whether it is related to national security, and they can ask the Chief Executive to issue a certificate. The Secretary for Justice had repeatedly said that why facts need to be we need to look into the facts, and also only the executive authorities would have access to confidential information to make a decision on whether the facts concerned constitute a national security offense. Mr. Chen, you said it right that in the Article 105 of the National Security Ordinance, NSNO, we want to, that is under the article, the Chief Executive is authorized, whether illegal proceedings have begun or not, he can issue a certificate to bring into effect the function of the law. And it also mentions that the Chief Executive has the autonomy to issue the certificate. So even during the trial, when it's underway, or even whenever there are circumstances where there needs to be a clarification now, especially with the subsidiary legislation, whether an act constitutes a violation of the national security law, the Chief Executive has the obligation and the rights to, in conformance with Article 115, to issue a certificate. And that is the right already given to him according to existing law. It's not something newly added to the regulation.
That's very clear. Next, Ms. Judy Chen. Thank you, Chair. After enacting the Safeguarding National Security Ordinance, whenever there are room for improvements, subsidiary legislation has to be made to clarify the enforcement mechanism and prevent legal disputes. The New People's Party fully supports it. Now I have some questions though. The secretaries mentioned that Section 7D is a fail-safe clause. Now when 7A, B, and C are not applicable, then 7D can plug the gap. Now, as previously mentioned, some highly confidential intelligence is only accessible by the chief executive himself. So can the chief executive, based on his knowledge of those information, ask the law enforcement agencies to conduct investigation anew? Now, if there are no elements fitting the national security criteria, can the chief executive ask the investigation to start anew so as to issue a certificate? Second question. The secretaries and even the chief executive have mentioned repeatedly that the regulation does not entail new offenses, penalties, or enforcement powers. So my question is only in regard of the procedures. Now the secretaries said that it would be very unlikely that the chief executive issue these certificates in the middle of a trial. On most occasions, the certificates would have been issued before the trial begins. However, there may be exceptional cases. If the trial has started and then a certificate is issued in the middle, then the case has to be dealt with according to the provisions in relation to national security law. So will there be a new trial? Or will the trial be converted into a national security case? Secretary. Thank you. Now, on the first question, when the chief executive has obtained information, can he ask the law enforcement agencies to conduct investigation? The answer is yes. Now, during investigation, if it is found that the case is in relation to national security, for example, succession or terrorist activities, then the case itself is a national security case. Then all the provisions in relation to investigation and so on applicable to national security cases would be enforced. No certificate is needed. So for cases mentioned in 7A, B, and C, those provisions already apply. No certificate from the CE is needed. Now, the new information reveals that there are national security elements, then provisions concerning national security would apply if the CE issues a certificate. But yes, these are rare cases. Second, concerning the rare cases where the CE issue a certificate during a trial, then the provisions or the trial procedures for national security cases would begin. Then, of course, a designated judge must be assigned. Now, whether there will be a retrial or new trial, it depends on the progress of the case and the decision of the specified or designated judge. The principle is we have to be fair to the defendant. Next, Mr. Stanley Ng. Thank you, Chair. Now, the executive and the legislative branches have to conduct timely review to enhance the legal system and enforcement mechanism on safeguarding national security. The FTU fully supports the amendment to the law. The provisions are very clear in stipulating that the chief executive may issue a certificate to define other offences endangering national security under the law of the Hong Kong SAR. Now, with the procedural matters regulation in place, as mentioned by some colleagues, Article 47 of the Hong Kong NSL, when hearing a case, if our courts encounters a situation where he needs to obtain a certificate from the chief executive in relation to acts endangering national security. Will the new procedural matters regulation make the courts less proactive in considering these matters, since the chief executive would issue a certificate anyway? In operation, would the courts be less eager to apply for a certificate from the CE? Second, with the enactment of the procedural matters regulation, do the Security Bureau and the DOJ expect that more cases will require certificates to be issued by the chief executive? Are these situations likely to occur in the future? Chair, I will take the first two questions. First of all, I gather that the question is whether the system would weaken the court's will to obtain a certificate from the CE. Now, to be clear, if courts encounter a situation requiring them to obtain a certificate from the chief executive, besides Article 47, in the interpretation issued by the NBCSC on the 30th of December, it is also stated that this is the responsibility of the courts. Now, we, as well as the members of the public, are confident that the judiciary will fulfill and uphold this responsibility in full. So I don't see why this mechanism would weaken the resolve of the courts to fulfill their obligations. On the contrary, the regulation can make the courts, as well as the law enforcement agencies, more proactive. During the investigation stage, we can rule out the uncertainty as soon as possible and make the entire proceedings more certain. On the second question, the procedural matters regulation will not lead to an increase in the number of certificates being issued. Now, the system is already in place. In the future, it will still be the chief executive who issue a certificate. Now, in the past, we need to obtain a certificate from the chief executive, and besides, we need to explain to the court that the certificate means that the offense is in relation to Section 7D. Now, we don't have to interpret that anymore. With the certificate, it means that the offense is a national security offense, and there is more certainty now. Mr. Holden Chow. Thank you, Chair. I support the making of this subsidiary legislation. Of course, this is a mechanism to effectively uphold national security. Now, at the joint panel meeting when we discussed the proposal, the secretaries emphasized that, firstly, the regulation does not expand the scope of the law. Now, even with a certificate issued by the chief executive, the punishment will not be more heavy simply because there is a certificate. Now on the scope, there are no new offences. My follow-up question is, now according to my recollection, in the same room when we discussed the enactment of the Safeguarding National Security Ordinance, when we were scrutinizing the bill, the government emphasized that the SNSO puts a lot of emphasis on the restriction of the law enforcement agency's power. When application is made to detain or restrict the movements of the person under investigation, they have to apply to the court. In some Western jurisdictions, the law enforcement agencies can detain the suspect without applying for a warrant with the court. So can the Secretary reassure us? The regulation has no effect on the restrictions imposed on the law enforcement agencies in enforcing the law. It's still the same as the SNSO. All the provisions and the mechanisms and the restrictions are the same. There is an equal importance attached to the restriction on the law enforcement agency's powers. Also remember clearly that when we were vetting the bill on the restrictive measures, the administration has been very clear on that. Yes, Mr. Holden Chow is right. With the regulation, when there are certificates classifying a case under Section 7D as a national security case, then the provisions and proceedings applied to national security cases will apply. These include that we need to deal with the cases fairly and in a timely manner. The case will be heard by a designated judge, and also we can extend the detention period. But to do that, we need to apply with the courts. Unless a magistrate makes an order otherwise on the request of the detainee, otherwise the statements can be in Chinese only. So all of these provisions are already in existence in the original ordinance, and we have to apply for an order with the court, including apply for extending the detention period or denying a meeting with the legal representative. So the safeguards are still here. Also remember that there are some cases in foreign jurisdictions. Warrants or court orders are not required for extending the detention period. Yes, that's the case for the UK. Mr. Peter Shiu. Thank you, Chair. Now, after the 2019 Colour Revolution, members of the public understand that national security and the city's stability is very important. After the enactment of the SNSO, we are quite stable. However, the international geopolitical landscape is treacherous. Now, in face of changes unseen in the past century, we have to uphold security and stability. That's very important. So the Liberal Party fully supports the amendment. Now, over the past few days, I've heard a lot of worries from members of the public, one of which is that by issuing certificates himself, the chief executive does not require an application from the court. I understand where the secretary was coming from. In dealing with these cases, the information held by the courts must be less than the chief executive, because the chief executive would have confidential information as well as a macro perspective of the situation concerning whether just anyone would be caught by the regulation. Now, for those who are not committing criminal acts, they would not be affected. Even for those who have committed criminal acts, they would only be dealt with according to the existing legal framework. Now I have a scenario for you. Now the CE can issue a certificate. So when a case is not brought before court, before the case is brought before court, for example, if a police stop and search and found someone with a detonator on himself on the street. Now when the police ask for the person to unlock his phone, he may be uncooperative and it would require a court order to unlock the phone. Now that person may be trying to create chaos and fear in Hong Kong, and that may be in the nature of national security. If a certificate is issued, we would allow the police to unlock the phone immediately to find out the whereabouts of the bomb so as to crack down on the terrorist activities. Secretary, thank you. That's a power in the implementation rules for Article 43. The police has to apply for a court warrant to request the person to provide the passcode to the phone unless there is an emergency where the public's life would be at stake. So the system is consistent. If we are investigating a terrorist activity, when we begin the investigation, we already suspect that this is a national security case. So there is no need for us to apply for a certificate because we are already investigating for a national security offense. If we started out investigating for a non-national security offense and then we found it to be true, and we found it to be a national security offense in the middle, and then after the chief executive has issued a certificate, then according to Section 7D, it would become a national security offense. Then we can resort to this power under Article 43 to unlock the phone without a warrant. Now, this regulation is good for the majority of the public. Those who should fear it is the minority who seeks to endanger national security and those with collusion with foreign elements. So this is a good thing for most of us. Professor Leung, thank you. First of all, I support the government to clearly classify those offences under Section 7D in the SNSO. So with the enactment of the regulation, we can better protect the innocents and also deter those who would like to chance their luck to endanger national security. I agree that in relation to the enforcement and definition on matters in relation to national security, the clearer, the better. That would clear up the gray areas. However, with the regulation enacted, it does not mean that the offences under Article 47 of Hong Kong NSL and Section 115 of the SNSO are fully covered because there will be a lot of uncertainties brought about by technological development. So this is a start only to deter those who would like to cause harm to the society. Now, for those who would like to make false accusations, these people will always exist. There will always be people who undermine our law. So I think publicity and education are very important. So actually, those criminals always resort to the same tricks. So we need to address these smearing acts square on. Now, concerning the power of the chief executive to issue certificates to classify the nature of an act, that's an inherent power in the law. Even without the regulation, the chief executive still has the power. The regulation only tells the public clearly that the chief executive would do so, will resort to the power when necessary. So the regulation does not affect the rights in sections 4 and 5 of the SNSO. That is, the defendants enjoy the same rights under common law jurisdiction. For example, presumption of innocence, and also the rights in the International Human Rights Convention, and also the rights in section 2 of the SNSO, that is the rights in the basic law. So whenever an alternative offense is in the nature of national security, then the proceedings for national security cases would apply. Section 115 of the SNSO is clear. It says any legal proceedings. So this is an inherent power given to the chief executive in the SNSO, so I support it. Thank you.
請司長回
Secretary, would you like to respond? The first point is that under the Hong Kong NSL and SNSO, there are principles guiding the safeguarding of human rights, and also under Section 153, when the court receives a CE certificate, then it would be binding on lower courts. I think the understanding is correct, especially the first point. We are talking about a piece of subsidiary legislation. We have to follow the principles set out in Article 4 and Article 5 of the Hong Kong NSL, and we have to safeguard human rights and safeguard the rights of the defendant. Nothing will change. Mr. Thomas So, I already said I support the enactment of the procedural matters regulation, but at that time we don't have the text of the regulation, and now we have it. We can take a good look at it. There are people outside saying that the CE in invoking this mechanism will interfere with the court's power, and these people include some law professors. They are saying that the power of the CE to issue a certificate to certify that an act involves national security will take away the same power from the court. But the court has to follow the Hong Kong SA, the Article 47 of Hong Kong NSL. If the court has doubt, he would have to ask the CE to issue a certificate. We must clarify the matter here. Now the regulation is very clear. Section 1 is about Section 70 of the ordinance, and Section 2 is about alternative offenses will also be deemed to be of the same nature. And also under Section 3, to avoid doubt, it says, to avoid doubt, Chapter 4 of the Hong Kong NSL and provisions of the laws of the Hong Kong SAR that are applicable to an offense endangering national security apply to A, B, C. And under A is a case that is such a case by virtue of Section 1(2)(a), and that is those covered by the CE's certificate, and the case will be deemed to be an offense endangering national security. And then we have B and also C, which states that any proceedings in connection with a case mentioned in paragraph A or B. So it says any proceedings in connection with a case mentioned in paragraph A or B. Many people are confused about the coverage. There are offenses, there are acts, and there are cases, and there are also proceedings. A case in connection with an offense, and also any proceedings in connection with a case, etc. Can you please clarify the boundaries? Well, may I suggest that we seek an answer to your last question in our cross examination, and also is that the right understanding in that Article 47 will require the court to seek the CE's certification. My understanding is that the court may ask the CE to issue a certificate when it has doubts. Well, the court has a duty to ask the CE to issue a certificate. If you look at Article 47 itself, in case whether a certain act concerns national security, the court should seek the CE certificate. And also, according to Article 47 of the Hong Kong NSL, if in the proceedings of a court, whether the case or the relevant material are in connection with national security, the court should ask the CE to issue a certificate. So the court is obligated to do this. All right, we would defer your last question to the cross examination. All right, now we have Ms. Maggie Chan asking question for the second round. 4 minutes. Any other member who would like to do the same? No? Ms. Maggie Chan. In the question and answer involving the Secretary for Justice, we all know that we are trying to clarify the meaning under Section 7D of the SNSO. And Section 7D is a catch-all provisions. And we're not creating any new offenses or new procedure by virtue of the procedural matters regulation. Under the common law principle, the judiciary should respect the delineation of matters concerning national security as determined, as assessed by the executive authorities. Especially in a foreign case, Somoro, it states that whether something is considered concerning national security is a matter for the executive not for the courts, not for the judiciary. The judiciary is only responsible for exercising its jurisdiction independently. We are a common law jurisdiction. We have similar principles as in other common law jurisdictions. There are some people trying to scare people, saying that this might affect foreign investors. Faced with such a smearing campaign, and the fact that there are other people saying that the subsidiary legislation in question will affect our business and investment environment, would the administration consider sending delegations to try to explain things in other places, and that the critics are really engaging themselves in double standard? Well, actually, as a matter of fact, the court would respect and accept the executive's assessment in such matters. And in this case of Samoro, it was a Privy Council case in 1916. It's an established case for over 100 years. It's well accepted in common law jurisdictions. So this is a very fundamental principle which is acceptable to many jurisdictions. Some people say that this will affect the business environment in Hong Kong. Actually, in the white paper on the promulgation of the Hong Kong NSL, there's a chapter on the implications for the investment environment of Hong Kong. And what is not in dispute is that Hong Kong is now in a stable conditions, and we have economic development since then. So there's no doubt that we should that we would be affecting our business environment. Well, actually, we have surpassed Switzerland in certain investment sphere, and we're number one. Well, actually, with a more stable environment in Hong Kong, we'll be able to attract more investments and achieve better economic development. And of course, we should explain to other places that our national security legislation is just like what other jurisdictions are implementing. People are spreading false information, and which is certainly not true. For example, the subsidiary legislation would not turn something which is not an offense concerning national security into one concerning national security. As chairman of the subcommittee, I think I'm duty-bound to help members understand the purpose of the subsidiary legislation in question. And this time, the subsidiary legislation is within the boundary set out by Section 110 of the SNSO. I was involved in the scrutiny of the SNSO or the SNS bill, and that is to safeguard national security and to better implement the national security legislation, including SNSO, and also the interpretation of the MPC of Article 7 and Article 11. We can enact subsidiary legislation under this power. And we understand that we are not doing anything that would add uncertainty to Section 7D. and according to some established court case, the case of Ms. Ng Hao Yi and Ms. Jimmy Lai, apart from the 4 offenses, there will be another limb and other offenses concerning national security under the law of Hong Kong. And that's a similar wording under Section 7D. And that is offense engendering national security. But there is also reference to case. So other offenses endangering national security under the law of Hong Kong SAR, and that is to say, offenses outside the 4 main categories. So we need to delineate and define what is meant by other offenses endangering national security under the law of the Hong Kong SAR. So we should welcome the clarification brought by the subsidiary legislation, so that you have more certainties whether you are the subject of an investigation or you are facing a court trial. The 2 secretaries have indicated now that we have a catch-all provisions, and we can clarify what it means by the CE mechanism, and also under Article 11, Section 110, the CE is empowered to make subsidiary legislation, and now we can clarify that the procedures involved in such a offense covered by the CE certificate. We are now just clarifying the applicable procedure. We are not creating new offenses. I think this is a clarification process. So I need confirmation from the administration. Madam Chair, your understanding is correct. All right, we now proceed to cross-by-cross-examination, since no member would like to ask additional questions. Let's scrutinize the Chinese version first. Our legal advisor would concurrently scrutinize the English text. I think the Secretary Bureau would ask the Deputy Secretary for Security to walk us through the provisions, and the legal advisor is invited to remind us if we need to pay attention to certain matters. We're now scrutinizing the safety, national security, procedural matters, regulation. There are 3 sections. The first one, Section 1, is to specify circumstances in which offense is offense endangering national security under Section 7D of the SNSO. There are 3 subsections. First, the application, the scope of application. Second, on the issue of the CE certificate, when it can be issued and the effect of such a certificate. And the Section 2 is the first subsection is about the application. It says, 1A, this section applies if A, in the case a person is investigated as to whether the person has committed an offense, and second, arrested for being suspected of having committed an offense, or 3, charged with an offense in respect of an act, whether or not together with any other acts, and B, the Chief Executive issue a certificate under Article 47 of Hong Kong NSL or Section 115 of the SNSO to certify that the act involves national security. And that is a certificate has been issued, and the issue of the certificate is to safeguard, is to specify whether the act was in connection with an offense endangering national security. And the power of the CE to issue such a certificate is always there. And the CE's certificate is just to delineate whether the offense is an offense concerning endangering national security. The penalty, the evidence required, and all remain the same.
根據第一款
Section 2 is that on the issue of the certificate, whether before the commencement or during the course of any proceedings of the case, A, the case is a case mentioned in Article 41 of the Hong Kong National Security Law, regardless of whether the act was done or the prosecution was brought before at a time or after the Hong Kong SAL came into operation. And B, the offense mentioned in subsection 1A, 1, 2, or A3 is for the purpose of the case and any proceedings in connection with the case and offense endangering national security under Section 7D of the Ordinance. You need to notice that, as mentioned by the two secretaries and also in answering legal members' question, the Chief Executive Certificate can be issued before trial begins, because national security cases are complex, and there could be a scenario when, in the early stage of investigation, the police did not collect all evidence to prove that the case involves national security. If after more investigation, then involvement with national security is found, then there may be a need to issue the certificate. So therefore, Section 2A says that the certificate can be issued at different time frames. And if the criminal case concerned involves national security, then the Chief Executive can issue during the certificate during the investigation or when the legal proceedings have begun. And what's also deserves your attention is that where the act was done or the prosecution was brought before at a time or after the Hong Kong National Security Law came into operation, the case could also be deemed as involving national security. So we said the subsidiary legislation has not introduced new offences or made any changes to existing NSL or provisions in the NSL. So therefore would not actually violate the principles of retroactivity under basic or under the human rights laws in Hong Kong. So members have questions. Maggie Chen? Yes, Chairman, I'd like to ask about 1(1)(a), where it says that anyone in a case is investigated as to whether he has committed an offense. In Chinese, it's 作為. And also in Section 2, there is this word 作為 in Chinese in the provision. So this Chinese expression appears more than once. So this expression 作為 in Chinese, can it be interpreted as act and activity? Why did I ask that? Because it could mean an act and activity under the Article 3 of Hong Kong National Security Law. Hong Kong's legislature and judiciary can penalize acts and activities endangering national security. So both acts, the words acts and activities are used. So we did add the expression and activities in that provision. Article 8 of the NSL, there's also the mentioning of acts and activities. So of course we refer to the Chinese version of the NSL as the final version, but in the English version it uses act or activity. But in a regulation, the Chinese it says 作為. But in the English version of the regulation, the translation reads act only. So, well, that's the context. My question is, well, for the Chinese expression 作為, does it cover act and activities? Administration? Ivan? Oh, well, I understand Ms. Chan's question. That is, this is the NSL provision you mentioned, which mentions acts and activities. But remember, we need to actually see that. I'm sure my colleague can give you more details. My brief answer to you now is that in general chapters and ordinance chapter 1, there's a definition in Hong Kong for the Chinese expression 作為. Now I'll hand over the time to Mr. Leung, Ivan Leung. Yes, it's mentioned by the Secretary in general interpretations, ordinance chapter 3, 作為 in Chinese is interpreted, which also is applicable to this regulation. The interpretation is that it covers a host of acts. That is, basically it covers everything. So I can supplement by saying why in Chinese only says 作為 without following the use of acts, phrases, acts and activities in the Hong Kong national security law. In drafting local law, even in those involving national security law, we abide by the criteria for common law drafting. So in the principal legislation, that is in relation to the NSL, many of the provisions related to offences, they use the Chinese expression. Therefore, we follow that style in our regulations, draft of the regulation. But basically, since we have the definition in the chapter 1 of the generations or generalizations ordinance, so I think the Chinese will cover all cases indeed. So in other words, based on Cap 1 that you mentioned in Chinese 作為 would cover a host or series of, it covers all series of acts and a series of illegal omissions and illegal omission. But we need to actually have a macro perspective because our source is the national SAL. So that means that your interpretation is such that it does cover all acts and activities. So that's clear. Next one is Chen Siu-hong. That's exactly what I wanted to ask you, following up on what Maggie Chen asked. The administration's response let me understand why you chose the wording, and you also clearly said that in English, ATCX, according to the relevant ordinance, the meaning is clear. Now, for this subsidiary legislation, I think the application is the same, but the subsidiary legislation is closely related to the principal legislations. I want to make it clear, however, I'd like the administration to explain further. Article 115 of the SNSO, it doesn't use acts and activities. It says that whether acts involve national security or whether an act or matter involves national security or whether any material involves state secrets, because you're making reference to Article 115, if you use the word or interpret acts including activities, and then meaning may be clearer, particularly for the public without any legal knowledge. They might wonder why in some provisions only the word "as" is used and others "acts" and activities are used. Can you clarify further? Thank you for your question. If you look at Article 115 of the SNSO, that is about when the Chief Executive can issue certificates, that is a scenario, as we explained, that actually is written in such a way that it ties in with the writing of Article 47 of the Hong Kong National Security Law. So it ties in with the writing in that piece of legislation. And in the scenario covered by the regulation, this regulation is all about criminal acts, as both secretaries said many times, because we will not make legal acts turn them into offenses. So for the context for this regulation, in the context of this regulation, since we are addressing criminal acts, then we should use the Chinese term 作為, because that can tie in with Chapter 1 of the relevant ordinance. Secretary for Justice. Article 115 originates from Article 47 of the Hong Kong SAR, so we need to have consistency in our wordings. So now, me personally, just now the Deputy Secretary mentions about Section 2, that is in relation to the certificate issued by the Chief Executive. That is when it can be issued, whether legal proceedings have begun or not, or whether the proceedings are underway. My question is, as I mentioned during the joint meeting, in some cases, it could have happened before the NSL came into operation, but then with prosecution made by the police and Department of Justice, they found that, contrary to the previous thinking, they confirmed that the case did involve national security. And then in that circumstance, the Chief Executive would be in the position to issue a certificate because the concern is found to involve national security. So, but why do you write it in this way? That it's whether the act was done or the prosecution was brought before, at the time, or after the national security came into operation? Or so you sort of, or the certificate is issued whether before the commencement or during the course of any proceedings of the case. We're now talking about new criminal acts now. I mean, what is the purpose of writing it this way? As mentioned in, it's as written in Section 2. As we said, there could be a chance that a case had happened before the NSL came into operation, but after legal proceedings began or investigation found that it did involve national security. So through this mechanism, the case could be defined as a national security case. But it's something that happened before NSL came into force. So what can we charge the case with? Because that's the case happened before the law came into force. So therefore, we said that whether before the commencement or during the course of any proceedings of the case. So because we could not impose a charge on someone before the law came into effect. Okay, thank you for your affirmation, because this is although in line with the principle, important principle in the human rights law in Hong Kong, Article 12. Sorry, I need to extend the meeting by 15 minutes first. Now, next one is Judy Chen. I just want to see if my understanding is correct. That is, now, the certificate is issued before or during the course of any proceedings. My understanding is that when a case, is it that when sentencing has been made, then the certificate would not be issued. And also in Section 2A, that is, the case is a case mentioned in Article 41 of the Hong Kong NSL, regardless of whether the act was done or the prosecution was brought before, at the time or after the Hong Kong SAL came into operation. So both secretaries just now clearly mentioned that the latest amendment has no retroactive effect. But I don't want to see unscrupulous individuals taking advantage of the provision I just read to mislead the public. Can the secretary, any secretary, give us possible scenarios to explain why there's a need for Section 2A? Any scenarios that you can share with us? Maybe my colleague. Well, let me share with you a scenario. I said this before, actually I can say it again. Say, in terms of procedure, that is before NSL came into operation, after it came into operation, people were concerned whether we can charge someone with a national security offense if the case happened before it came into operation. Of course not. So it's not possible that we can, through this subsidiary legislation, charge someone with one of the 4 offenses under SAL for something that happened, and that happened before the law came into operation. Because under the human rights law, we should abide by the principle of non-retroactivity. So you cannot, but you cannot say that this new subsidiary legislation violates the human rights law provision. So that's our purpose, to make things clear, that to let people know that we definitely would not violate the legal principle of non-retroactivity. That is in relation to Article 12 of the Human Rights Law. As for the drafting itself, Mr. Leung, please. Yes, your first question about the issuing of the certificate by the Chief Executive, when it can be done. In Section 2, it says that it can be issued whether before the commencement or during the course of any proceedings of a case. That is for a criminal case. That is at all stages of legal proceedings. If all the proceedings have been finished, then under the current mechanism provided by the regulation, then no certificate will be issued. And also, the 2 secretaries also reiterated earlier that in actual practice or implementation, we believe that the police must have carried out due investigation, and they, even before the commencement of any proceedings, basically they would be sure of where there's a need to ask the Chief Executive to issue a certificate to prove that the act or the case involves national security. So it's not possible that is when the sentencing is announced, that the certificate will be issued. That's not likely. Okay, thank you. So, Deputy Secretary, take us through Section 3, please. Okay. Section 3 is, it says the certificate is not liable to be questioned in any court, and no legal action of any form may be instituted in respect of the certificate. So explained by the secretaries, in common law jurisdictions, there are a number of examples showing that judgment related to national security, because of the nature of the cases, the executive authorities are in much better position and empowered to handle those cases. So therefore, the judgment and assessment of the executive authorities must be shown by the court, and that's a common principle in common law jurisdictions. So we are following the relevant principle, and there's no such thing as interference with the judiciary. And I think we can let the court to rule on the cases in line with national security principles. That's Section 3.
Thank you. Section 1, subsection 3. I think this must be how it is drafted. Otherwise, it would be incompatible with Article 47 of the Hong Kong NSL. That is, the chief executive's certificate is binding on courts. Section 115(3) also mentioned that on receipt of the chief executive's certificate, then it is to be regarded as having obtained a certificate issued by the chief executive. So since it is legally binding on the court, then the certificate is not liable to be questioned. Otherwise, it would be contradictory. Reverend Peter Kuhn, follow-up question. Yes, question means a question against the contents. Is that right? So the question in subsection 3 does not mean a question to challenge the authenticity of the certificate. That is correct. So the certificate is not liable to be questioned. It means that the contents of the certificate is not liable to be questioned. Yes, Mr. Mok, please continue. Section 2. Section 2 on alternative offences. If A, in a case a person is charged with any offence endangering national security, including an offence that is such an offence by virtue of Section 1, Brackets 2b, in respect of an act, whether or not, together with any other act, then the alternative offence is, for the purposes of the case and any proceedings in connection with the case, also an offence endangering national security. Now, it's worth noting that if a person is being convicted of an alternative offence in a case endangering national security, even though the offence elements are different, then however, both offences are arising from the same act endangering national security. The nature is the same. So this would avoid any legal disputes in the future. And also concerning the maximum penalty, the standard of proof as well as the burden of proof for the original offence would not be affected. So even though the alternative offence is certified by the chief executive as an offence endangering national security, it will not change the penalty level for the alternative offence. Thank you. The legal advisor has a question here. Thank you, Chair. Now, I believe members would understand that the legal effect of Section 2 is that if a person is being charged with any offence endangering national security, and then in the same case a person is charged with or convicted of an alternative offence of the same act, then the alternative offence is also an offence endangering national security. Now, concerning the mention of the same act in 2b, can the administration provide an example of an act belonging to the same act, and also a counterexample on an act not belonging to the same act, so that the alternative offence is not an offence endangering national security? That is a very good question. Through the examples, we can understand what alternative acts will be an act endangering national security and what are not. Which government official will take the question? You are all very eager to answer the question, just like us. Which government official? Mr. Ivan Leung. I am instructed by the Secretary to answer the question. Thank you, legal advisor, for your question. earlier on as the joint panel meeting and just now, both the secretaries mentioned an example. For example, a syndicate colluding to plant bombs in multiple government buildings or police stations across the territory, then they would be prosecuted through Section 24 terrorist activities in the SNSO. That would be the original offense. The alternative offense would be attempting to create bomb to endanger property and life in the criminal offense ordinance. So concerning the act or the same act, that means the action of planting bombs at various locations. So that would lead to the alternative offense. And according to Section 2 of the Procedural Matters Regulation, that alternative offense is also an offense endangering national security. And a counter example is the following scenario. Say the police, when conducting investigation, for example, on this syndicate's premises, it is found that in the premises there are dangerous drugs. So, of course, the person will be charged with the offense of possession of dangerous drugs. But obviously, possession of dangerous drugs, the act in itself is distinct from the act of planting bombs. So the charge is not being initiated for the same act. So possession of dangerous drugs, even though the offense appear on the same indictment, it is not an alternative offense. So according to Section 2, it does not apply. Possession of dangerous drug will not become a national security offense. So with these examples, I think members now understand why this provision is needed to clarify that some alternative offenses are also national security offenses. Otherwise, it would be unreasonable because the act and the facts are the same. Thank you. If there are no questions, Mr. Benjamin Mock, Section 3. Thank you. That is the last provision. To avoid doubt, Chapter 4 of the Hong Kong National Security Law and provisions in the law of the Hong Kong SAR that are applicable to an offence endangering national security apply to A case mentioned in Article 41 of the Hong Kong National Security Law, including a case that is such a case by virtue of Section 1(2)(a). B. A case in connection with an offence endangering national security, including an offence that is such an offence by virtue of Section 1(2)(b) or 2. And C. Any proceedings in connection with a case mentioned in paragraph A or B. Now, in response to Dr. Thomas So's question just now, this provision is for avoidance of doubt. It seeks to stipulate that all the national security law offences in the HKNSL and the SNSO are criminal offences in relation to Article 41. That includes cases which are already classified as endangering national security or criminal acts endangering national security. Now, 3C means that cases and offences endangering national security and the legal proceedings arising from that. For example, application for copious order in relation to detention and also other similar proceedings. Thank you. That's the copious opus order. Thank you. Concerning the three provisions, are there any follow-up questions? Thank you, administration, for your explanation. Now we will now invite the legal advisor to confirm that the drafting of the English version of the regulation is proper. We have found no issues with the English version of the regulation. Now my question for members and the administration is whether there will be amendments moved concerning the regulation. Members, administration, no. Now, at this point, I think the subcommittee has completed the scrutiny process for the regulation. Once again, I thank all of you for participating in the scrutiny process. We have completed our work on the procedural matters regulation. Now at the meeting, members have asked questions in relation to the policy matters, the legal principles, as well as the contents of the regulation. Now the team led by the two secretaries have given satisfactory and targeted answers in relation to members' questions. Examples have also been given. Now, taking the opportunity of this meeting, the administration has explained to the public that the regulation merely aims at enhancing the certainty in the carrying out of the provisions in relation to the Hong Kong NSL as well as the SNSO. There is no new offences, penalty, or enforcement powers entailed. It is also within the scope of Section 110 of the SNSO. The administration has confirmed that all individuals facing criminal prosecutions will continue to enjoy the safeguards under the Hong Kong NSL, SNSO, as well as the Bills of Rights and the Basic Law. They will receive a fair trial. As the subcommittee has completed scrutiny for this piece of subsidiarization, to complete the proceedings as soon as possible, I suggest the subcommittee strive to make a report to the House Committee as soon as possible. That's tomorrow's House Committee meeting. Is there any objection? If there is no objection, in the capacity of the chairperson of the subcommittee, I will send a letter to the chairman of the House Committee to make this suggestion. Once again, I thank all parties, including government officials, as well as subcommittee members and the secretariat and the legal advisor, for your support of our scrutiny work so that we can complete the work swiftly. Item 3 of the agenda. Now, alternatively, I would like to ask the secretaries, are there any supplements? I would like to give my thanks. I thank the chairperson and the members of the subcommittee for discussing the matter with us in such short notice. We have expeditiously dealt with the regulation. It also highlights how serious we are in scrutinizing the regulation. It is already 4:13. We have spent more than 2 hours on discussing the regulation. Members have asked many valid questions and points of concerns on behalf of the members of the public to rule out misunderstanding or even deliberate accusations. It has given us a chance to clarify our position. So once again, I thank the chairperson and all the members for your support. Mr. Chris Tang, if you have anything to say, we have to extend the meeting by 15 minutes. I'll be very swift. Once again, I thank all members and the chairperson. Now, with this discussion, I think members and the public have understood the regulation better. It highlights the positive interaction between the executive and the legislative branches. Thank you. Very well. Item 2, any other business? There being none, the meeting is adjourned. Thank you.